Thank you for the invitation and for the kind introduction. I have to make already now one correction. I'm not working with the Bundeskartellamt, but only with the Monopolies Commission. That's a small commission, an advisory commission to the German government, and much less famous than the Bundeskartellamt, much less important than the Bundeskartellamt, but much more independent, perhaps. So, and this is as I see my role here. I thought it would be perhaps interesting to have kind of an advocatus diaboli here, to have some ground, some basis for a discussion. I will come to the conclusion that consumer choice is a valuable concept, very valuable concept, but to pour some water into the wine, consumer choice is not sufficient to explain competition law in its entirety. That's my thesis. And why that? Because I think that competition law is concerned with competition in the first place, which means, in my interpretation, which is based on old-fashioned German law, it's about competition not only in the sense that competition protects or benefits consumers, but it might benefit also other participants of the competitive process. So, to sum up this preliminary difficult word statement, I would say I concur with Professor Lande that consumer choice is very valuable in the sense that one should not concentrate on price issues, and I think most people working in competition policy and law would agree on that. And I would even assume that many people in the US would agree on that. So I'm a little bit astonished when people say, oh, competition law is only about price issues. So I concur with this, that competition law is much richer. But I would even go one step further than you and say it is so rich that it even does not only benefit consumers, but also sometimes other people. Before getting to this conclusion, I would like to make one preliminary remark about German competition law. Our act, German Act Against Restraints of Competition, dates from 1957. It entered into force on the 1st January 1958, on the same day as the EEC competition rules in the EEC treaty. And because of this parallel enactment, one might think that both sets of rules should be interpreted precisely in the same way. However, the wording of the German Act was for a long time somehow different from the European rules, and in some respects it's still different. And also based on these differences, the German Federal Cartel Office as well as the courts have for a long time felt free to deviate when applying German law from European competition rules. As I'm asked to talk about choice or consumer choice in German law, I would first refer to old-fashioned German law in this sense, so the German law of this stage when it really differed also in its wording from the European law. And with respect to this stage, I would very clearly say, of course, this law was benefiting consumers in the sense that not only price was an issue, but quality was an issue, variety was an issue, and everybody would have agreed upon that. So in this sense, this was paradise for Robert Lande. Now I'm talking in the past tense. I'm a little bit unsecure how to restate German law as it is today, because everybody knows in this room that EU Regulation 1/2003 orders the predominance of European law. And on that ground, the German legislator adapted more and more, at least the provision about cartels to Article 101. So today there is a very interesting question, and I don't really have a safe answer on that. Is German law precisely the same as European law in this respect, at least, the cartel provision? Do we have to interpret it precisely in the same sense? Or is there still leeway? Is there still certain autonomy? So German researchers, German scholars discuss this issue, but I think there is a wide agreement that in principle it wouldn't make sense to have a very different interpretation from that of the European provisions, and so I think the interpretation should follow those lines. So if I'm asked to talk about German law, I think today I also have to talk about European law, because that determines to a large part German law. For me, it's also not so easy to say what the position of European law regarding consumer choice as a concept is. Nicolas Banasevich has already said much about that. I just, because of time constraints, I agree in all respects. I concentrate on the issue in my short speech whether competition law is confined to consumer concerns. And when we start with the wording, this doesn't, with the wording of competition law, we read, the following shall be prohibited, and so on. And then the example A, directly or indirectly fix purchase or selling prices. This indicates that competition is protected here in two directions, not only downstream but also upstream. Also, the fixing of purchase prices seems to be interesting to this provision. And if we go one step further to Article 102, we see the same duplication in the description of abuses, abuse of dominance. We read, an abuse may consist in directly or indirectly imposing unfair purchase or selling prices. So it seems as if also the imposition by a dominant buyer of purchase prices, unfairly low purchase prices, is within the scope of European law. That's at least the appearance from the wording. And the question is whether this still holds, or whether today we are wiser, smarter, more advanced, or I don't know, backwards, whatever. The question is whether one can say that the European law is only concerned with consumers. I think this, at least the wording, gives an indication that sellers might also be protected by European competition law, and consequently, as it was in former times, I omitted a decision saying that from the German Bunderskartellamt, which is in the slides, Kammergericht decision. The interpretation, I think, is not arbitrary to say that also sellers are protected against buyer cartels, and also sellers are protected against buyer power, abuse of buyer power. And if you agree on that, you notice that the consumer choice approach, when you take the word, the element consumer seriously, seems to be too narrow. That's my main point. And that's why I asked Paul Nihul to shorten the phrasing of my topic, not to say consumer choice, but just to say choice. So this is the main point I wanted to make. But you may say that all of this is the product of fantasy of a professor who doesn't know what's happening and who doesn't know the practice or the precedents. At least we have some indications that the protection also of suppliers against the power of purchasers, of buyers, either abuse of power, either purchaser cartels, are within the scope of the competition rules. And I would like to give this hint. There are not very many hints, so I think this is not a safe statement I'm making here. But there is a decision, and it's so well restated by Richard Wish in his treatise that I just cite from this book. The ECJ agreed with the Commission that the complainant had to show that the price was low, that what was the case of abuse of buyer power, that the price was low in relation to each individual firm, and that it could not rely on average or undifferentiated figures. The interest of the case is that it demonstrates that just as charging an excessively high price can be abusive, so too can the extraction of an unfairly low one demanded by an undertaking in a dominant position on the buying side of the market. So this gives an indication that this could be the law, and as long as it's not overruled, it's still the law of the European Court of Justice. Okay, so that's an indication. Now one might say, okay, this shows that European law is perhaps richer than US law, if US law or US practice, whatever, concentrates on price issues only and on low prices for consumers only. I am not at all a specialist in US antitrust law. I've found, of course, decisions, American court decisions, mentioning consumer welfare as the main goal, enhancement of consumer welfare as the main objective of US antitrust law, the first of which dating from 1979, that was the Reiter versus Sonneton decision by the US Supreme Court, where the Supreme Court said that Congress apparently designed, that's a quote, the Sherman Act as a consumer welfare prescription. And that term refers back to Robert Bork's influential work, Antitrust Paradox of 1978, the word consumer welfare prescription. However, Bork, as everybody knows, I think, used the term consumer welfare in an idiosyncratic sense. According to him, consumer welfare is greatest when social resources are allocated in the best way. So this doesn't really give us evidence that only consumers are at the issue here, or are the issue here. However, and that's the point I wanted to make, there are even some decisions, US decisions, even Supreme Court decisions, giving us a hint that the same is true that I pretend, or the same as I restated as my interpretation of European law, the same can be seen as being the law in the US, which means sellers are also protected. And I just want to give you 2 or 3 quotes. In 1940, in Secone Vacuum, the US Supreme Court stated that under the Sherman Act, a combination formed for the purpose and with the effect of raising or depressing prices is illegal per se. So buyer power, buyer cartels seem to be within the scope. In 1984, Judge Posner, whom we wouldn't suspect of being an ordo-liberal, reasoned that buyer cartels are illegal per se. Just as sellers cartels enable the charging of monopoly prices, the buyers enables the charging of monopsony prices, Judge Posner said. And as late as 2007, the US Supreme Court decided in the Weyerhaeuser case, complicated case, that predatory pricing and predatory bidding claims, driving competitors from the market, are analytically similar. And Gregory Werden, who is a very prominent US scholar, US economist, interpreted in the way that predatory bidding that drives competitors from the market, predatory bidding by high bids, driving competitors from the market, and leads to monopsony is condemned under Section 2 of the Sherman Act in the same way as a predatory pricing that excludes competitors and results in a monopoly. So the result of a monopsony is seen as somehow similar as the result of having a monopoly. For all who are interested in this reasoning of Gregory Werden, I refer to his paper he published in the Antitrust Law Journal in volume 74. So in my view, the contention that consumer choice is the only issue in competition law would not hold, neither in German law, nor in European law, nor even in US antitrust law. Consumer choice is a major concern, clearly, but the law is not limited to this one goal. And my proposition, because I don't want to end here with a negative statement, is that one could go this one step further, that I went here and draw the conclusion, which is here written in the last sentence. The goal of competition law is to benefit not only consumers, but in general the opposite side of the market, which are often consumers, but sometimes suppliers. Thank you very much.